Ami Chapi Epi. Petakinde Owasi, Chante Washte and Apechu Zapie. Ramona Keto Stately and Makiapie, Damakota. Dedakota ia Upse Usewi, Nie. Isayanti Hetchet Hawahie. Ka Shakpe Edwati. Good evening. I want to say Yahipi Kimwashte. Welcome to everyone here on the webinar tonight. So the Minnesota Indian Education Association Board of Directors welcomes you as we offer a series of monthly speaker events. The purpose of providing these events align with our mission, that the association shall establish and maintain communications and the promotion of quality education and unity for Native people. Without the ability to meet and greet you all in person, we have created this series. It will become a part of our library of resources as well, so that you can access it as a YouTube video whenever necessary. If there are topics or speakers you'd like to hear from in the future, please make your recommendations at ramona@minnesotaindianeducation.org. So we also want to thank our sponsors tonight, sponsored by the Shakopee Mdewa Sioux community and the tribe's Understand Native Minnesota Narrative Change campaign, and also to the We Are Still Here Minnesota project, who spotlight and make visible Native peoples and their governments today. So I'm really proud to announce Tad Johnson and Joseph Bauerkemper today in a brief overview of federal, tribal, and state relations.
Thank you.
Great, thank you. Yeah, thank you, Ramona. Thank you, Billy, Ethan. Thanks so much for having us. I'm Joseph Bauerkemper, and it's the honor of my career to get to tag along with Tad Johnson at some of the wonderful stuff, the wonderful outreach and service that he does in the world. And so I'm really pleased to be along with him and with you all this evening. I'll mostly be in the background helping to move around some of the visual material, but I get to start us off by facilitating a little bit of a quiz, or really more like a game show that we're going to play together as we get going. So I'll ask you to find an internet connected device. It can be the same device that you're using with Zoom if you're able to get up a web browser or some such, but it certainly can also be a mobile device. I'm going to get on my vintage mobile phone here, and I'm going to enter this URL that you should see on your screen into the web browser. So that's z.umn.edu/MENTI, z.umn.edu/MENTI. So if you would join me by entering that web address into some kind of gadget, see what happens here. And I'm going to switch my screen share so that you can see both sides of this Mentimeter, it's called. Some of you may be familiar with it. It's a little interactive polling tool that we're going to use. All right, so here we are. And now, as I advance the screen, you should have a quiz question before you on your device that's also reflected on the Zoom screen share. And we've got folks finding it and entering in their answers. Very good. All right, thank you. So if you still want to join us, you should be able to see in the upper right corner of the Zoom screen share the URL z.umn.edu/MENTI. And so this first question, no doubt you all got it pretty much correct. How many Indian reservations are within the state of Minnesota? Hey, thanks, Ethan. So he's put the URL over in the chat for you to find as well. And indeed, there are 11 Indian reservations within Minnesota. You all are educators, far better trained than Tad and I, but we have made it a habit of doing this at the beginning of some of our sessions to activate your existing knowledge. And we've got some really great insight into the chat about the reservations that have been established across Minnesota, which often look really different historically than they do today, or at least as the state and federal government see it. But indeed, today we've got 11 federally recognized Indian reservations within Minnesota. 9 is sort of a red herring answer there. 573, until recently, that was the number of federally recognized indigenous governments, federally recognized tribes and Alaska Native villages and such in the United States. I think that's gone up to 574 in recent days, but here we are on the right track with that 11. That's the reservations in Minnesota. I'm going to go ahead and move us along to the next question here, and your browser might travel automatically on your gadget. It might ask you to join us on the next screen. In any case, the question at hand is, the power of tribes to self-govern comes from where? All right, so a little bit of a controversy here. The majority of you have noted that this is an inherent authority, which is indeed the case, as Tad and I see it. Tribal self-governance, tribal sovereignty, tribal nationhood, this is an inherent authority, an indigenous authority arising out of deep history of the relationship between peoples and one another, between peoples and places. That is the source of tribal self-governance. This is variously acknowledged and often neglected, misunderstood by the federal government and by state policy, but it is an inherent authority. We sometimes say to our students up here at UMD, if you find yourself freezing, nervous, not sure what to do when you encounter a quiz or test question, think about inherent tribal sovereignty. If you put that down and connect it to whatever's going on, you might get at least a few points. But a key principle there, tribal sovereignty, tribal self-governance is an inherent authority. It's not derivative of the federal government. It's not derivative of state policy. Next one up here, true or false? The US Constitution acknowledges tribal sovereignty. All right, great. So Tad will get into this in a touch more detail in a little bit, but indeed the US Constitution has a provision that contemplates tribal nations as sovereign entities, thereby acknowledging tribal sovereignty. Again, Tad will get us back to this topic in a moment. And then a follow-up question here, another true or false. State law generally applies in Indian country. Do you find that to be true or false? All right, we're seeing a good balance here. So indeed, this is a false statement, and Tad will discuss this also in a moment, especially when he talks about some of the foremost federal Indian law cases through which the federal government, by way of the institution known as the Supreme Court, acknowledges that state law does not generally apply in Indian country. And Indian country, as many of you probably know, is a term of art, right? A technical, legal, political term that refers to Indian lands held in trust, Indian reservations, all land within the boundaries of Indian reservations. And so a follow-up question related to that previous one, which entity currently decides whether or not state law applies in Indian country? Yeah, so we know our stuff here. The US Congress is currently the entity that at least understands itself and does have the practical force of law to decide whether or not state law applies in Indian country. Would that it were the National Congress of American Indians, right, which is not a formal governance entity, but that might be a better place to go to make this decision. In any case, it is the US Congress that makes this determination for practical purposes currently. And then the final question in the little quiz here, almost a rhetorical question. True or false, treaty rights are special race-based privileges given by the federal government to Indians? All right, indeed, this is false. It's at least triple false, I would say. Right, treaty rights are not special race-based privileges. They are not race-based. They're accorded in relation to political status of Indian people. This is something that Tad will discuss here in a moment. And they are not rights given by the federal government to Indians. Rather, treaty rights are actually fundamentally rights given by Indian nations to settler peoples. And then inherent pre-existing rights are often reserved and reinforced through treaties, but they existed beforehand. They're not created by the treaty. Indigenous rights are not created by the treaty. Settler rights are created by the treaty, and that's something that we'll also come back to in a moment. So thank you all. We've ascertained, as we no doubt suspected, that there's quite a bit of existing knowledge for us to activate and connect to. Tad, we've got a question coming through both in the Q&A and some components of it in the chat as well, seeking some clarification that there are 11 Indian Reorganization Act or IRA tribal governments in Minnesota, but that there are many more reservations than that should not be confused with IRA governments. And I'm wondering if you can provide a little clarification on the suggestion in the quiz here that there are 11 reservations in Minnesota.
Yeah, so I think the question was about like a lot of reservations got created in the Treaty of 1855, which is correct. And I think Veronica listed out Gull Lake, Rabbit Lake, Pekagama Lake, Leech, Winnie, Cass, Sandy, Rice Lake, and Mille Lacs. Yeah, right now the federal government acknowledges there's 11 reservations, and if you count the Minnesota Chippewa tribe, there's 12 federally recognized tribes. But I know there's an argument that a lot of folks have that there's those reservations never went away, and I think there's a lot of scholarship that needs to be done on that, and I think a lot of people are working on those issues. So. And there are executive order places that are like the Lake Vermilion part of Boyce Fort was made into part of the reservation under an executive order, and so Veronica is correct. Under the Treaty of 1855, all those reservations got created. So,
Great, thanks. All right, so Ted, now you're going to remain in the hot seat there and work us through the history of federal Indian policy, which really is fundamental to thinking about tribal relations at the state level, of course, at the federal level, at any kind of level. It provides the reality, the context in which all of these things happen. As we know, it's quite determinant of many of the engagements. So Tad and I have worked over time to create a metaphor. We call this our river of time, as sort of our shorthand language. We use the river as a metaphor of a timeline because it helps us to think about the twists, the turns, the smooth sections, the rapids, the tumultuous sections of the river. And it also helps us to remember, right, that the past is never really past. I think that might be a Faulkner reference, that that things that are upstream continue to have an impact downstream. So, so Tad, if you would work us through the eras here.
Yeah, so early days, you know, the beginning of Europeans coming here, the period for international relations, the creation of the United States, the removal period, of course, the establishment of reservations, which you just chatted about a little bit, the period of allotment and attempted assimilation, the Indian Reorganization Act from 1930 to 1950, the termination period, and the self-determination period, which we're still in today. So we'll be running through all those in great detail. So we'll start with the beginning, and there's a couple of things that permeate the entire lecture, two ideas: sovereignty, the right and ability of a people to determine their own destiny and governance, sovereignty. As Billy and Feather and some of my other students that are on would tell you, that if you forget everything else I say, remember inherent tribal sovereignty, something that we always had, never gave up, and I always make the argument that we still hang on to it. Then there's the trust responsibility, which is kind of like a result of the big real estate transaction that took place in the 19th century as a result of creating reservations and kind of my tribe is on the Iron Range, Boys Fort, and so billions and billions of dollars of iron ore got taken off the Iron Range. Meanwhile, Boys Fort kind of got moved from a large part from Lake Vermilion over to Net Lake, which is a great wild rice lake, and that's where a lot of folks live. But as a result of staying within that 100,000 acre boundary or so, the United States also promised into perpetuity certain obligations. So healthcare, housing, etc., obligations owed by the United States to tribes, usually in treaties, sometimes in statutes like the Indian Healthcare Improvement Act, and sometimes in regulations. And so the way the late Senator Inouye used to look at these things, and President Obama did as well, those obligations flow not just from the BIA and IHS and HUD, but from every single corner of the United States government. So when President Obama came in, he said, "I want consultation policies with all the agencies, no matter how remote you are from Indian country." So anyway, so those two ideas, tribal sovereignty, which we've always had and always will have, the ability to determine our own destiny, and the trust responsibility, which are promises that the United States made to tribes, those will permeate the longer story as we go through it. So we can move on, Joseph. And if I miss anything, just speak up. So when Europeans first got here, they started trying to figure out how to deal with the Native American people that were in North and South America. The great battle for North America took place. The settlement began with the Dutch, the English, down further south in Central America, the Spanish, the Portuguese, up north around Boston Harbor and Plymouth, English settled, and English brought over a large population with them. The French settled around, or starting the fur trade around the St. Lawrence River and then down the Great Lakes over to the Mississippi. But they all had to figure out how to make deals with Indians because the tribes had a significant military might. So a lot of these were treaties of peace and friendship. The Spanish were frequently not terribly nice to tribes, as you know, demonstrated by Columbus and some of his progeny. But so in North America, they started making European-style agreements with tribes. So after the Great Battle for North America, which culminated in after the Dutch had taken over New York, they eventually got taken over by the British, and it ultimately came down to a battle, the French and Indian War between the French and the British. And so England ended up taking over the continent. And during this time, um, uh, a lot of the Europeans were using something called the doctrine of discovery. A lot of them were predominantly Catholic countries. And so they used papal bulls and other things promulgated by the Catholic Church. And the first European sovereign that would reach land and would make the deal with Indian tribes. It's the doctrine of discovery. The Spanish and the English had more of a favorable view with regard to land title than the Americans ended up having. So, but anyway, the French and Indian War ends in the Treaty of Paris in 1763. And then the colonists start feeling this urge to break away from England. And during this time, a lot of English trained lawyers, Thomas Jefferson and Alexander Hamilton, James Madison, are kind of leading the colonies during the Revolutionary War. And during the Revolutionary War, the government of the colonies was something called the Articles of Confederation. It was a fairly loose confederation, and what it said essentially in the Articles of Confederation was that the central government is supposed to be dealing with the Indian tribes unless it infringes on the rights of the states. So that was an exception that swallowed the rule, because the states continually said, hey, you're infringing on our rights as states to make deals with Indians. And so when Alexander Hamilton and John Jay and James Madison were writing the Federalist Papers, they decided we've got to give a stronger presence in the federal government for dealings with Indian tribes. Thank you so much. And so when the Constitution was written, there were a couple of important provisions that were put in there. In Article 1, Section 8 of the Constitution is the Commerce Clause. What the Commerce Clause says is that Congress has the authority to regulate commerce with foreign nations, with states, and with Indian tribes. And if you think about those three entities, those are three different types of sovereigns. So that's a place we can point to in the Constitution indicating that Indian tribes are sovereign. Also, because, the British Crown had been making treaties with Indians, and all of these folks I mentioned were all English trained lawyers. It was a natural step for the new United States to enter into treaties with the tribes, which they began almost immediately as a country. And so in the Constitution, there's a supremacy clause that says the treaties are the supreme law of the land. And federal treaty making authority, treaties are negotiated by the executive branch. So in the early days of the Department of War, took on Indian affairs. Later on in 1849, when the Interior Department came around, they started making the treaties. But treaties are ratified by a 2/3 majority of the Senate. And we saw over the weekend how hard it is to reach the 2/3 majority of the Senate. So getting a treaty through is not easy. And some 600 plus treaties got negotiated, but about 377 got ratified by the United States. So anyway, so keep those ideas in mind, that there was this long period of colonization, but the United States kind of continued this period of colonization for the tribes, and wanted the central federal government to have control over Indian affairs as opposed to states. And that was the original idea, but it kind of fell off until it was cleared up in a series of cases known as the Marshall Trilogy. The first one had to do with land, Johnson versus McIntosh, and it's quite a complicated case, but it was the first of the Marshall Trilogy. And Marshall dug back into the doctrine of discovery and kind of went through some of the history. I just went through the French and Indian War. The British stepped into the shoes of the discoverer, so to speak. And when the United States defeated the British in the Revolutionary War, the United States stepped into the shoes of the discoverer. And so, ergo, when Marshall wrote Johnson versus McIntosh, he invoked this Catholic doctrine of the doctrine of discovery and said, we are stepping into the shoes of the discoverer. And we have exclusive negotiating rights, not states, not individuals. And, the whole continent was lying in front of the United States. And the title that Marshall said the tribes had was the right to occupy the land. This is called either Indian title or original Indian title or Aboriginal title. And so it's a pretty, the right to occupy is a lesser standard than the English or the Spanish used when they invoked the doctrine of discovery. So Johnson versus McIntosh is, there's a book called Some of the Worst Case Ever. My friend Walter Echo Hawk wrote something called Courts of the Conqueror, the 10 worst federal Indian law cases. And he does a whole discussion on Johnson versus McIntosh. And anyway, but they ended up chatting ultimately about who had the right to make the land deal with tribes. So the Cherokees had this same thing happen that Boys Fort had, which was gold got discovered on their land. And the state of Georgia, they were located at that time in the state of Georgia, was making a bunch of rules and laws over who could come and go on Cherokee lands, especially because gold had been discovered. So they started passing a bunch of laws, making requirements for who could come and go on Cherokee lands. The Cherokees were very ticked off, and they were very, very smart and well-read. They read the Constitution, which essentially said if you're a foreign nation, you can go straight into the U.S. Supreme Court. So the Cherokee Nation took the state of Georgia into the U.S. Supreme Court. And Marshall said, well, you guys have sovereignty, but you're not foreign nations, you are domestic dependent nations. And so, basically, that was kind of the holding of the case. And so you didn't really rule on what the merits of what the Cherokees were looking to. But what was important that got said in that case, and lawyers call this dicta, was that the United States is like a guardian and the tribes are like a ward. And it's very paternalistic language. He said the tribes are in a state of pupillage and the United States kind of has to take care of them. And so I guess the only positive thing, to the extent that it's positive, sometimes not everybody views it that way, but the United States became the trustee of tribal lands and resources. And anyway, so the third case, when I'm doing tribal state relations, with Joseph and I do on a fairly regular basis, we've trained about 3,400 state employees and 300 more this semester. So Worcester versus Georgia. And Worcester was a preacher, and along with several other clergymen, got arrested for preaching on Cherokee lands without permission of Georgia. So he got arrested, and he ended up getting the former Attorney General of the United States, William Wirt, to represent him. Georgia ended up not showing up for the case or filing a brief. And so that kind of ticked off John Marshall. But on the merits that the Cherokees were looking for, Marshall did rule on here. And he said, okay, you wise guys in Georgia, the laws of Georgia shall have no force in Indian country. And so in general, state laws are not applicable in Indian country. Now, the caveat to that is, which comes later, is that unless Congress does a later enactment, and we'll get into that more. But when we're teaching the state of Minnesota employees, I said, just I tell them just remove the name Georgia, stick in Minnesota, and as a general rule, that's still the case. It's, as a general rule, the laws of Minnesota don't apply on reservations. So that's the importance of that case. And I think we'll have time for questions at the end. So we kind of use this analytical tool in MTAG and other places. And I just, in general, when analyzing a federal Indian law or a treaty or anything else, you have to ask yourself, has Congress expressly acted to limit tribal authority? And if not, I always make the argument that tribes retain the inherent tribal sovereignty to do anything. So, I mean, any unusual rights that tribes have, whether it's the right to hunt, fish, and gather, or the right to have reservation boundaries, or the right to do gaming, usually we went and argued that in court and went and ultimately the Supreme Court kind of did this similar analysis. And Felix Cohen, who's the great scholar of federal Indian law, I can't read the whole quote there, Joseph, because my head's too big. But anyway, but he essentially said it's one of the fundamental principles of Indian law that those powers that are what is not expressly limited by Congress remains in the dominion of tribal sovereignty. So if you're working with a tribe, always make, and your rights are questioned. Frequently it's by the state or the county. Always make the argument that if Congress hasn't expressly taken the right away and it was written into a treaty, make the argument that tribes retain the right inherently. So anyway, is there any way to so I've got 4 boxes on my screen. I don't know if there's a way. I can't see all the words on the screen.
Sure.
I don't know if there's a way. Wait, maybe I can do that myself.
Yeah,
There.
It would be on your end. You got it?
Yeah, there, I got. Yeah, I just eliminated myself. So the idea of removing Indians to west of the Mississippi that chatter started as early as George Washington and Thomas Jefferson. And so Jefferson, really interesting election of 1800, if you ever want to read an interesting election. But Jefferson basically wrote a letter to the governor of the territory of Indiana, who later became president, William Henry Harrison, and said, trade furs with the tribes. The tribes wanted, metal goods, pots, pans, knives, etc. And he said, but an Indian trading post try to get Indians into debt so that we can get their land, because that's what the United States was after. Jefferson had this idea in his head that it was going to take 20 generations to move the United States. It only really took 3 to go from coast to coast. And under Jefferson, Lewis and Clark went and explored the Pacific Northwest, and Jefferson purchased the Louisiana Purchase. And so suddenly the United States grew exponentially under his administration. But, Jefferson has a bit of a checkered past with regard to African Americans and Native Americans. So anyway, but he still got his head on the nickel. So Jackson got elected in 1828, and he was the first president from what they used to call the West. This was Tennessee. And so Jackson had been an Indian fighter, and anyway, he got through Congress in 1830 a kind of a general statement regarding Indian removal, and it would be done to tribes specifically in the Southeast, but the Indian removal occurred all over the place. And the Cherokees who are depicted in that painting were removed under the Treaty of New Echota. So this is a common theme in federal Indian law and policy. The United States Congress will make a general statement on a policy, and here Jackson got the Removal Act through, and then Congress enacted a series of treaties removing the southeastern tribes to either Arkansas and then later Oklahoma. So during the cold winter of the late 1830s, the Cherokees removed, and several thousand died on the trip. And that's another sad tale in American history. So anyway, but a number of tribes got moved around, including the Dakota out of Minnesota. So there was a Dakota War in 1862 because the Dakota were starving. Usually I have if I'm making this presentation, if I've got a Dakota leader in the audience, I have them do this part because they can address it better than I can. But as a result of they were starving, there was a war that took place, and subsequently the largest mass execution in American history took place, 38. They should have been prisoners of war, but they were treated as criminals. They were hanged, as a lot of you know this story. Over 300 were, Alexander Ramsey and Henry Sibley wanted to hang. Abe Lincoln pardoned all but 38. And anyway, then there was this exile where the Dakota were technically kicked out of Minnesota. So a lot of them had to go down the Mississippi and then up the Missouri and form the Crow Creek Sioux Reservation in South Dakota. Many of them hung out in Minnesota. Some of them came back. So we now have 4 Dakota communities in Minnesota. And I'm guessing a lot of you are tribal members from there. And anyway, so I mean, these awful removal things were happening all over the place. But the Dakota made it back into the state, and this is frequently addressed by our friend Kevin Jensvold, who frequently makes this presentation with us. And there's an act that he points out has never been repealed on this matter. So let's move on, Joseph. So as was pointed out earlier, a lot of reservations got created specifically in the year 1855, but from the middle part of the 19th century until around 1890, tribes were created through, up until 1871, tribes were reserving territories through treaties, later on some more by executive. And obviously these lands significantly concentrated where Indian people were located. And in Minnesota, Fond du Lac Band had a beautiful reservation where what is now Duluth and along Highway 23 on the St. Louis River. They got moved back into Cloquet. As I was mentioning, that lake got moved. The Boys Fort Band got moved from Lake Vermilion back into Nett Lake. So anyway, people got moved around into smaller areas. Mille Lacs, 61,000 acres. Boys Fort, 100,000 acres. Leech Lake and Red Lake managed to hang on to more land, but I mean, territories got significantly diminished during this times. So let's move on.
Sure. So I get to take us on a little bit of a brief excursion as we travel along the River of Time here. Those of you who maybe happen to teach an American civics class or a U.S. government class, or like me had to take it at some point in the 20th century, might remember learning that federalism, especially in the United States, is the division of sovereignty between the federal government and state governments. And that was my experience, and I was taught wrong. It's important to understand and to recognize and to make clear that U.S. federalism, it's it's always in crisis. It's always in a crisis of illegitimacy. So I don't mean to aggrandize it as a completely appropriate and solid thing. And I'll say more about that in a moment. It's also important to recognize that for whatever it might be worth, that US federalism is a three-legged stool. Tribal governments, as Tad has suggested, are the inherent original senior sovereigns of this continent. And then we also have state governments, which wield sovereignty, the authority to govern. And we have the general government, as it was called in the Constitution. We often call it now the federal government. So this is a three-legged stool. And I know that several of you out there, it's good to see so many friends, students, colleagues out there have heard me talk a little bit about this before. And I appreciate your indulgence to revisit it a bit, because I think it's useful for us to think about the story of the United States in relation to indigenous sovereignty and treaty relations. It's underappreciated, and this ends up creating circumstances that are simply not viable in our world and our relations with one another. So if we think about the picture, the story that Tad tells early with the French and Indian War, the British Crown engaging in diplomacy with tribal nations, some of what you have happening there is that tribal nations, under all kinds of complex circumstances, and yes, indeed, under duress and difficult circumstances, but also in many cases empowered by their great covenant chains of diplomacy, engage in those international relations with the British Crown. And these tribal nations decide strategically that they will give very narrow and limited permission to the British Crown to do certain things on this continent, to engage in a limited suite of governance activities over a limited set of places and a limited population within those areas. So tribal sovereignty is pervasive across this continent, right? Is that it has existed since time immemorial, continues to do so. And at the time when European powers were aspiring to engage with tribal nations in diplomacy, indigenous nations were the only sovereign authorities. And again, they made strategic decisions under complex circumstances to give certain permissions to, for example, the British Crown to engage in some governance, to wield some sovereignty. Now, as many of you may have heard, there's this little complexity called the American Revolution, in which the colonists, the subject of the British Crown, are frustrated with the British Crown's governance capacity and actions. They fire off what we would probably think of today as kind of a tweet storm. We know this as the Declaration of Independence, a bunch of complaints about the Crown, many of which, as we know well, emphasize anti-Indian sensibilities. They enter into a war, and these colonists win this war and therefore separate themselves from the British Crown. At the Peace of Paris, the end of the American Revolution, the British Crown hands over that little bit of sovereignty that it had obtained tribal governments to the colonies, which become states, right? So this is the origin of state governance authority. States are the successor sovereigns to the British Crown due to the American Revolution. As Tad mentioned, they create the Articles of Confederation to try to orient themselves, that is, the state governments do, orient themselves to one another. Doesn't work very well. And so they meet up in Philadelphia, come up with a new plan, poof, out of thin air, they invent this thing called the general government, the federal government. So they create the federal government. They write down a list of things they want the federal government to be in charge of. We call that list the US Constitution. So you can see here, right, that this governance authority on this continent comes from tribes. It's all derivative from tribal authority. The tribes decide strategically to grant a little bit of permission to the Crown to wield that governance authority. The Crown behaves pretty well beyond those permissions, ends up in a revolutionary war. The states inherit those permissions, again, behave well beyond those permissions that have been granted, create a federal government handing it some of those permissions. Again, the federal government behaves well beyond those permissions, and this is a significant problem that we live in under settler colonialism today. And so the federal government then starts talking to more indigenous nations and engaging in more diplomacy, creating more treaty relationships with tribal nations. And through those treaty relationships, again, under complicated circumstances, often under duress, but also making really good decisions in really difficult circumstances, tribes decide to share governance authority over more spaces and more populations, always reserving their inherent rights, or often reserving territories for their exclusive use and benefit, right, the reservations. And so the general government is gaining some more permission from tribal governments to engage in governance, always stretching and acting well beyond those permissions. And it creates new territories, governance territories like Minnesota Territory, for example, which often then become states like the state of Minnesota, as an example. So this is a map from Why Treaties Matter, a website with which many of you are surely familiar, and it shows kind of the basics, the fundamentals of treaty territories and reservation lands here in Minnesota. The key here, and the thing that I often emphasize, is that treaties create settler rights. Without treaties, there are no settler rights. There's no chance at legitimacy for settler governments like the United States, like the state of Minnesota. It's only through treaties that these things can exist. And so I will say to a state agency, for example, if you take yourself seriously and you think you exist, Minnesota Pollution Control Agency or whatever it is, right? If you think you exist, then your first order of business needs to be to mind your treaty obligations. Because if you are not minding your treaty obligations, you are undermining the premise of your existence, right? Your state of Minnesota, Minnesota agencies, federal government, so on. And so treaty relations are fundamental to the existence of settler polities, settler government entities like the state of Minnesota, but they're, as we know, deeply neglected, massively underappreciated. So we live in a circumstance of illegitimacy, right? These settler entities, these settler communities are not abiding by their treaty obligations and have not done so for a great while now. And so there's very little legitimacy to the workings of the federal government, to the workings of the state government. And this is something that is underappreciated and misunderstood by many. And it's something that whenever I have an opportunity, I like to talk about it. And I would encourage you all to do that too. In order to maybe make this a little easier, I've created a very simple web page. You can find it at the URL shown there on your screen, z.umn.edu/treaties, and it just has some really basic resources for thinking about treaty rights and obligations, for thinking about treaty relations. And so I wanted to emphasize that story of America. It correlates to the reservation era, it correlates to the international relations era, the constitutional era, and it correlates to today, because like I said, treaties really are the narrow pathway toward a kind of community, a kind of legitimacy that we don't yet have here when we think about the United States, when we think about the state of Minnesota. And so educating people that we work with, that you all work with out there on this matter is vital and will continue to be so. So thank you for going on this little diversion along the side of the river of time. We'll jump back in it, but before we do, Ted, we're getting some questions in through the chat and through the Q&A interface. Please, those of you out there, continue to use the Q&A interface to submit your questions. You can also put them in the chat, and it's a little easier to track when they are in the Q&A interface. But one of the questions that we have that relates to an era that we covered, and we'll pick up some of these questions later as we move into those eras along the river of time. But Ted, one of the questions we have is about the Marshall Trilogy. Do those rulings, do those decisions, Marshall Trilogy, impact Minnesota Anishinaabe nations, for example, even while the treaties were signed after those decisions were made? What's the relationship there?
So when the Supreme Court makes a decision, there's a doctrine called stare decisis, which is kind of like the thing decided. And so there's a lot of cases that we hate from the American Indian perspective. And unfortunately, they once the U.S. Supreme Court has made rulings, we have to live with a lot of the results. And for tribes, a lot of those are, negative. There's many really bad ones to come. So, and they still, cite to those cases. In fact, like Worcester versus Georgia is one of the most cited cases after like Marbury versus Madison, because there's a lot of Indian law questions that go up to the U.S. Supreme Court. So the Marshall Trilogy is frequently cited to in Indian law cases to this day. So yeah, unfortunately, there's a lot worse cases to come. So, unfortunately, it's a kind of an awful history starting about now here. So I wish a lot of things didn't apply, like this. 1871 treaty making ends. So one of the jobs I had was I was staff director and counsel of the U.S. House Subcommittee on Native American Affairs, and frequently, when trying to make Indian policy, our enemies were on the Senate side. Frequently, uh, this was a point in history when, uh, for a while, the Republicans were controlling the Senate, and there were very conservative ones. Later on, I was there during a time when the Democrats, well, like it is right now, the Democrats controlled the House, Senate, and the White House. But frequently, the House is at odds with the Senate, and so as I mentioned earlier, the executive branch negotiates treaties. The Senate ratifies the treaty, and so the U.S. House was left holding the appropriations bag. So what the House used to do quite a bit, and if there's a money issue, whether it's appropriations or taxation, it has to start on the House side. So what they used to do a lot is put a rider, which is, there's two types of legislation that Congress does. There's authorizing legislation, like here are the rules that, here's the Indian Healthcare Improvement Act, that's authorizing legislation. But appropriations legislation happens every year. And so how much money the federal government is going to provide to the IHS to implement the Indian Healthcare Improvement Act is an appropriations issue. And so they're really, appropriators are not supposed to be authorizing legislation too, but they used to do that all the time and call it a rider, and they'd stick it on to. So in 1871, the House decided, okay, we're going to end treaty making as we know it, and existing treaties are going to be good law. But so from here on out, Congress is going to be the unilateral authority when it comes to Indian policy. So suddenly we got diminished from a government to government, a true government to government relationship, with a treaty. So, I mean, they only make treaties with foreign nations or Indian tribes, but we got, lowered down to the standard where Congress, and this is just as folks are moving west and it becomes more advantageous to make, to start making laws without upholding tribal rights. And so treaty making ends in 1871, unfortunately. So then this is a slippery slope of really bad policy. So Captain Pratt, who opened up the Carlisle boarding school, said, his slogan was "Kill the Indian, save the man." And so they would take kids as young as 4 off of reservations and send them to boarding schools. And so this disrupted communities, and they would, and a lot of you folks know that, I mean, they'd send kids to boarding schools, not allow them to speak their language, not allow them to visit their homes, not allow them to practice their traditional religions. They try to Christianize them. So this has caused generational historical trauma to folks, and so to this day there are folks recovering because their parents or grandparents went to boarding school. This is a picture of the Vermilion boarding school in the early 1900s. And there's my grandfather and my grandmother are both in this picture. So the guy with the hat is my grandfather, John Anderson. The girl with the round face is my grandmother, Mary Tutloff, who later became Mary Anderson. She was born in 1900, so I'm guessing, looks like she's about 10-ish there. So I'm guessing this is around 1910. I think he was born in 1896, so he looks about 14. So anyway, so this is the Vermilion boarding school. The boarding schools had a lot of disease, tuberculosis. A lot of them have graveyards around them. And this was an attempt to assimilate Indians into the mainstream of the population. This case is going to seem a little strange to bring up, but there's a purpose for it. So in 1883, a tribal leader named Crow Dog ended up getting into a fight and killing a tribal leader named Spotted Tail. Crow Dog is in the lower one and Spotted Tail is above. And so the issue came up, if an Indian, and this was in Dakota Territory, so if an Indian kills an Indian in Indian country, who has jurisdiction? Well, the Supreme Court says, if an Indian kills an Indian in Indian country, Indians have jurisdiction. So, technically, so there were traditional remedies for murder and all kinds of crimes that the tribes had. So the Crow Dog family would pay the Spotted Tail family and a certain number of horses every year or some other payment. But then the United States was kind of outraged about that. They're like, why don't we have jurisdiction over that? And so in 1885, they passed the Major Crimes Act, which, originally there were 7 major crimes: murder, rape, other things. Now there's over 20 major crimes. The act is still in place. But essentially, suddenly major crimes would go to federal district court, misdemeanors would be in tribal court. And then there was a question that came up. Does Congress actually have the authority to assert that kind of power in Indian country, US versus Kagama? And the case affirmed congressional authority to pass the Major Crimes Act. And then Congress starts going nuts on Indian country. It was Katie bar the door. What happens next is one of the great travesties in American in all of American history. So in 1887, Congress passes the Dawes Act, or the General Allotment Act, which was an attempt to impose land ownership onto Indians. And so they would take multiples of 40 acres on reservations, and they give 80 acres to the Crow Dog family, 80 acres, maybe the Spotted Tail family was a little bigger, they'd get 160 acres, but they were multiples of 40 acres frequently. And the way this happened in Minnesota was Knute Nelson, whose statue is in front of the state capitol, got the Nelson Act through with the great encouragement of timber companies in Minnesota. And so it was an attempt to allot lands in Minnesota. So the upper map here is the Fond du Lac Reservation, and you can see the various land types here. And reservations became a patchwork quilt of land ownership. And so let's see, so the green are Fond du Lac land, the orange are county lands, the kind of pink are state lands, and the white are private lands. And ironically, the University of Minnesota owns a big chunk of land in the middle of this reservation, the Cloquet Forestry Center. And so the Fond du Lac band's not real happy with that. My job is to nag the University of Minnesota on things like this, because there's stuff that goes on at the Cloquet Forestry Center that the Fond du Lac band doesn't like. So I'm constantly, trying to bug the university on that. And then there's Leech Lake over here. And you can see the multiplicity of colors here. So the red lands are American Indian Trust lands. Yellow lands are federal lands. Corporate lands are pink, municipalities and county lands. The green are private lands, the blue are state lands. And so, so Leech Lake, I mean, what was going on at the time was, a good deal of the great stands of ancient timber in Minnesota had been cut down by the timber companies. And so our US senators and the governor and everybody were kind of conspiring to get inside the reservations in Minnesota to cut the great ancient timber stands that were still there, great stands of white pine and red pine that were inside the reservations. And so, like looking at a map of Bois Fort, a lot of it is still owned by Diamond Match, who wanted wood. Other, a lot of Leech Lake, folks wanted first timber, then pulp wood, and then the Chippewa National Forest got stuck in there. And so anyway, tribes got screwed all over the place here. So as a result of the the allotment acts, both the Dawes Act and the Nelson Act, 2/3 of the land inside of reservations were put into non-Indian hands. And so there was this great travesty of justice. And the way this was supposed to work is these allotments were supposed to last for Indian people, and who the ownership of land was kind of foreign to a lot of these folks. And in 1906, Congress passed the Burke Act, which allowed tribes, Indian individual allottees, people who owned allotments, to sell their land early if they were like, if they signed a paper that said they were 1/8 white. And so suddenly on rolls all over the place, there appeared these 7/8 bloods, which is a fraction that's really hard to get to. And so it screwed up rolls for decades afterward, and goes on to this day. Also, if you could claim to be a civilized Indian, somehow you could also sell your lands early. So lands that were not lost that way, some were lost to tax forfeiture after the 25-year period went on. And so 25-year trust period, and Indians didn't know they were supposed to pay taxes on their land. So anyway, it was an awful act, and it was, and those of you who might have allotments out there, there was no inheritance provision in the General Allotment Act, and in the allotment acts in general. And so the lands kept dividing and dividing and dividing. And so it got to the point where the Bureau of Indian Affairs was processing checks to, like 300 people who were, heirs to a particular piece of land, checks that would cost $350 to process, and they go out to the heirs of the allottee, and they would be checks for like 37 cents or something. It was just ridiculous. That was what the Cobell litigation was all about. And so ultimately the US government settled with 300,000 allottees, but Eloise Cobell led that litigation. When Ben Nighthorse Campbell was chairing the Senate Indian Affairs Committee, the legislation finally went through. But it wasn't a very good deal for allottees, which it never is for tribes or Indian people. So anyway, we should move on, I guess. So if you look for books on really crummy cases that came down for African Americans, frequently Plessy versus Ferguson, or the Dred Scott decision are in there for Native Americans. This is Lone Wolf versus Hitchcock, was a case. Lone Wolf was one of the chiefs of 3 tribes that made a treaty with the United States. Hitchcock was the Secretary of Interior. And what the treaty said was, the terms of the treaty can't be changed unless 3/4 of the adult males vote to make the change. However, after the treaty, Congress passed an act giving away a lot of the land that was promised to the 3 tribes under the treaty. And that case went up to the US Supreme Court, and Lone Wolf said, hey, there's, the supremacy clause that says that treaties are the supreme law of the land. How come Congress can step in and make these rules? That seems like it's contrary to the Constitution. That was Hitchcock's argument. And the Supreme Court and Hitchcock argued that the United States has total and complete power over Indian tribes, and if Congress wants to unilaterally abrogate a treaty, it can. And that the Supreme Court said that the United States Congress has plenary power over tribes, which is a substantial amount of power. From the tribal end, we always make the argument that we have inherent tribal sovereignty. So if Congress hasn't directly addressed the issue, we retain the sovereign right to do whatever, hunt, fish, gather, etc., retain boundaries, etc. So I was mentioning my grandfather earlier, and I about once a year, we'll take my kids to the museum at Boys Fort. And my grandfather's in a lot of the pictures with his cap on. And I asked my mom when she was alive, was grandpa like a camera hog? And she said, no, he was an orphan, and he actually lived at the boarding school. So he never went home. He didn't leave the reservation until 1917, when World War I started, and he joined up with General Pershing and the American Expeditionary Force that went over to France. And he was not alone. Between 9,000 and 12,000 Native Americans signed up for the military for World War I. And the interesting thing was they were not citizens of the United States. In fact, Indian people have fought in pretty much every war the United States has been involved in, from the Revolutionary War all the way through, to World War I, but they weren't citizens. Now, a lot of them didn't want to be citizens. They wanted to be, tribal members first. But by 1924, almost everything had been taken away. So that's President Calvin Coolidge, who was president at this time, with some Native American folks. A lot of tribes look at this as citizenship being imposed on them. Some people look at it as granted. Some of them wanted the right to vote, but they had to fight for it, and especially in some of the Western states. So when my mother was born, for example, Indians did not have the right to vote. She was born earlier in 1924, before this act passed. And so anyway, I got to tour Calvin Coolidge's house, and a guy who was touring it with me said he is considered to be the 6th worst president in the United States. And I said, well, he might move up now after last administration. So anyway, moving on.
Ted, before we jump toward the 20th century here, we got a question that came in through the Q&A relevant to allotment. So I'm going to pose that if you don't mind. Yeah. Let's say that allotted lands, if allotted lands were sold because of falsified documents, if there were falsified documents, whether the allottees falsified it or the purchaser falsified it, to say, perhaps that someone was 7/8 blood or some such, or for any other reason, can a sale based on falsified documents back then be challenged still today? Is there any avenue for remedy?
Well, that's a really good question. And, it seems like property law, there was so much scandalous stuff going on all the reservations, because what they would do, I know, at in certain reservations is like if a soldier had soldier script, they would they could like sell it to a timber company. So suppose you've gone through the Mexican uprising as a soldier or something in 1915, or you go through the Spanish-American War, and you get paid by soldier script as opposed to cash. And so you live in Illinois, you have no plans of leaving Illinois, and your name is Richard Smith or something. So timber companies would frequently go out and buy, there'd be Richard Smith and John Stewart and, all these soldiers that went through. They might live in Pennsylvania, and timber companies would go out and buy their soldier script, go in and say, and then get some local. And the courthouse, the big courthouse in Minnesota at that point was in one of the town, Cambridge. So they would go into Cambridge and say, "Hi, I'm John Smith. I'm John Stewart," and they'd be some flunky that the timber companies would put up, and so land fraud was going on all over the place. But with the 7/8 blood question is a really good one, because I think a lot of people were making those decisions without knowing what they were signing, and there was a lot of swindling going on. But unless it could be something, and I think what's needed in the United States is probably some kind of reconciliation project where a lot of these wrongs that were done with regard to land sales and purchases probably need to be remedied. Some kind of there was an Indian Claims Commission, but that didn't cover a lot of these allotted lands. And so right now, I think it is really difficult to get a remedy on that, especially if people hold title. And usually the law in Minnesota is they have something called a torrent system. And if property is held that way, a lot of the which most of the deeds in Minnesota are kind of held in by counties. It's hard to go in and make an argument against the chain of purchase and stuff. But I mean, it seems like a good now that we've got some folks that are friendly controlling Congress. That's something. I mean, from my perspective, there needs to be like a truth and reconciliation entity in the United States where we right some of these wrongs, because Indians were screwed so many different ways, and that's just one way. But I totally agree. There should be some option right now. If you take that to court, I don't think you'd have much luck unless Congress created an act for, the rectification of those rights that were lost by, essentially by swindle and ripping people off, Indian people. So, I mean, we'd love to see a lot of these wrongs corrected by the Congress, and I think that's the place we'd have to start, by getting an act through, which would provide for some reconciliation of all these ripoffs that were suffered over the years. So, anyway.
All right. Yeah, thank you. And thank you for those questions. Keep them coming through that Q&A portal there in Zoom. I know that we have a couple of questions that are waiting for us to respond to. We will get to those when we've made it to the moment in history with which they largely resonate. So keep those questions coming, and we'll continue to work them into the flow of the discussion here.
So the Miriam report kind of set out to look at conditions on the reservations as a result of the General Allotment Act. And the Allotment Act was supposed to, the do-gooders on the East Coast were kind of like, well, let's make the Indians farmers. Let's assimilate them into the mainstream of the populations. But the implements of farming were never provided. For the Westerners, it was kind of like, how do we get inside those reservations so we can get the good grazing land, the good timber land, And so when they would do the allotments, they would, if they ran out of Indian families, which they frequently would do, they'd declare the rest of, maybe 1/3 of the reservation public domain land. And so suddenly it would be opened up to homesteaders. And so suddenly there's now all these non-Indians moving onto the reservations. So the Miriam report kind of documented the levels of poverty, alcoholism, unemployment, the lack of implementation of the allotment policy, which was supposed to make the Indians farmers. It just, nothing was going on. These were a lot of anthropologists, including John Collier and other folks. And the entity that published this later became the Brookings Institute. And so this happened in 1928, and everybody knew that Indian tribes had gone downhill. So in 1934, that is Secretary of Interior Harold Ickes signing something with looks like some Plains Indians, and standing in back of him, the guy with the glasses, is John Collier. Harold Ickes was a progressive from Chicago, and John Collier was one of these anthropologists who saw the negative things that had happened as a result of the General Allotment Act. So Felix Cohen was the solicitor for the Interior Department, and he was the first person to do a treatise on federal Indian law. So a brilliant scholar. He, by the age of 21, he had both a law degree and a PhD, and died fairly young, but ended up saying, maybe if we treated Indians more like governments, they could, arise out of this terrible position we put them in with regard to the Allotment Act. And so the Indian Reorganization Act encouraged tribal constitutions and secretarial elections. And for Minnesota, it becomes important. The Minnesota Chippewa tribe, which is all the Chippewa tribes in Minnesota except Red Lake, is part of the MCT, which is an Indian Reorganization Act tribe. And so the Constitution got written in 1936. A lot of input from the Interior Department, and still, holds their elections. And the Minnesota Chippewa tribe essentially has three things they do together. They hold elections. They have land and trust together on the different reservations. So as a Boys Fort band member, technically, my band has some ownership rights in Mille Lacs or other reservations. And then there's membership. So if you have to be 1/4 blood quantum. Can I get that refill? Thank you so much. Oh, really? Oh, okay. Sorry about that. The Minnesota Chippewa tribe still exists today. They're looking at potential changes to the Constitution, but a lot of tribes did not fall under the Indian Reorganization Act. I mean, fairly large tribes. In the East, a lot of tribes have selection of their leadership by clan mothers. And there's places like the Navajo Nation and other large tribes that never fell under the IRA and just decided not to get under it. In fact, the majority of tribes are not under the IRA, but it kind of shows how the policy, what they were at least attempting to treat tribes more like governments during this period, but that didn't last real long, as you'll see by the next slide, I guess.
So Ted, before we move into that, we've got a couple questions. One of them relates directly here, and then one of them I'd also like you to take up here in a second. So one of the questions at hand, is Minnesota Chippewa tribe a tribe, or is it a federally recognized political entity comprised of 6 member tribes?
So that's a really good question. But the Minnesota Chippewa tribe is actually a federally recognized tribe, but each of the 6 bands are also federally recognized tribes. And it seems kind of odd, but that it's like a unique case in Indian country. And so, for example, when the Minnesota Chippewa tribe got created in 1936, the Red Lake chose not to. There had been a consolidated Chippewa agency for the purpose of delivery of payments and that sort of thing. And then the Minnesota Chippewa tribe organized in 1936 under the Indian Reorganization Act, and several bands participated in the organization of the MCT, but like in 1949 and 1951, as an entity, the Minnesota Chippewa tribe filed claims in the Indian Claims Commission. So from 1946 until 1977, the United States, you can't sue the United States without its permission. And so this was as a result of rewarding soldiers, American Indian soldiers who fought in World War II. And so they said, essentially the US said, we kind of, took a lot of Indian land without compensating and took a lot of timber without compensating tribes. So they allowed themselves to be sued, and the Indian Claims Commission was this sort of special court. So as an entity, the Minnesota Chippewa tribe filed a couple of dockets for the taking of land and the cutting of timber. And so in 1999, those claims got settled for $50 million. And then and that the Minnesota Chippewa tribe, the 6 bands had to argue how to divide up the money. The larger bands, like White Earth and Leech Lake, wanted it divided up on a per cap distribution. The 4 smaller tribes wanted it divided up in a 6-way split. And so at one point, Colin Peterson had a bill in for a per cap bill, and Jim Oberstar had a bill in for a 6-way split. And they brought them to Congress at the same time, and Congress said, you guys have got to go figure this out. So later on, they did a bill where they split the difference. So half of the money was awarded as a 6-way split, half of it was awarded on a per cap distribution basis. But that was where the Minnesota Chippewa tribe was acting as a federally recognized tribe, still under the as a tribal entity. So technically, there's really from the United States perspective, and I know there's argumentations about who's a tribe and who's not, but from the federal perspective, there are 12 federally recognized tribes in Minnesota, including the Minnesota Chippewa tribe. There's 11 federally recognized reservations, and I know there's a lot of folks that argue that reservations that the United States may claim went away still exist, and they have a right to make those arguments, and that might be litigated someday. So I won't really comment on that, but the U.S. Recognizes both the Minnesota Chippewa tribe and individual bands. You can only get like a gaming compact or a self-governance compact if you're a federally recognized tribe. And so all 6 of the MCT bands have both self-governance compacts and gaming compacts, whereas the Minnesota Chippewa tribe, decided not to go that route, and so they are, they basically the chairman and the secretary treasurer form the tribal executive committee of the Minnesota Chippewa tribe, and they are a federally recognized tribe. So, that's a screwy. It's different from almost any other tribe. So anyway, great question. Thank you.
Yeah, thank you. So we have another one on hand that asks us to think back to the treaties that we discussed and the lone wolf case on plenary power, but also to think forward to treaty rights litigation and current practice of usufructuary rights, natural resource treaty reserved natural resource rights. So here's a question. With congressional plenary power in place, how are usufructuary rights able to be used and asserted in court? For example, the Mille Lacs versus Minnesota Supreme Court case, how were usufructuary rights able to surpass the plenary power doctrine?
That's a really good question. What a couple of tribes, what many Chippewa tribes did when they were writing their treaties, like the Treaty of 1854, as they were writing that, they put into the treaty, the tribes did, that they retain the right to hunt, fish, and gather in the Arrowhead region of Minnesota. So Bois Forte, Fond du Lac, Grand Portage continue to exercise their treaty rights under the 1854 authority. The state of Minnesota will frequently not recognize these rights until a lawsuit is brought. And so that's what happened there. And then with the 1837 treaty rights, which is a swath of land that cuts through northern Wisconsin all the way over to Lake Mille Lacs in east central Minnesota. They also, the Chippewas, there were no state lines at that point. But the Chippewas again reserved the right to hunt, fish, and gather. And what the state ended up arguing, the state of Wisconsin and the state of Minnesota, was there was this presidential order from the 1850, I think it was from 1850, because these rights exist at the pleasure of the president. And so for many years, the Wisconsin DNR and the state DNR would arrest Chippewa people, Ojibwe people, from exercising their treaty rights. And my friends on the reservations told me that, they still kept spearing, they still kept netting, at night when nobody was around, and exercised their rights anyway. But when the case got brought in Wisconsin, first under the Voight task force, and I think Walt Brissett started that going down that road in Wisconsin. And then Judge Crabb ended up deciding in favor of the tribes that the 1837 hunting, fishing, gathering rights still existed. And then Mille Lacs was part of the 1837 treaty. And so Mille Lacs attempted a settlement with the state of Minnesota, and Mille Lacs was going to take a very small percentage of Lake Mille Lacs, like 5% for spearing and netting. And Bud Grant, this was 1993, and a bunch of folks, went to the legislature and said, no, let's litigate this. We can win it. Let's take it up to the Supreme Court. And so for the next 6 years, they fought in federal court. And after that, all the Wisconsin bands joined with Mille Lacs, and suddenly the entire 1837 treaty rights were on the line. So they won at in the district court in Minnesota, and then the Eighth Circuit, because the Seventh Circuit, where Wisconsin is, had already recognized the rights, and the Eighth Circuit actually agreed with them. So normally, if two circuits agree, they don't go up to the Supreme Court. But for whatever reason, the Supreme Court took the Mille Lacs case, and the tribes won it 5-4. So the court recognized the rights of the 1837 signatories to hunt, fish, and gather in this large swath of ceded territory, including Lake Mille Lacs. So now the entirety of Lake Mille Lacs is at play partly because of Bud Grant and company. But I mean, they reasserted their treaty rights, and that was a case where the Minnesota and Wisconsin Chippewa were denied their rights for many years, and the rights were recognized by the Supreme Court as never having gone away. Congress never having passed a law that forbade or took away those rights, and they ruled that whatever the presidential order said, it didn't take away the rights. So anyway, that's the story of that case, I guess.
Okay,
That lasted.
Good.
It's a oh, go ahead, Joseph.
Oh no, that's fine. We do have one more question here about MCT, and we'll see your creative thinking on this one. So, if an MCT tribe wanted to secede from the MCT today, how would it affect that tribe's trust relationship or legal status?
So, the Mille Lacs band actually tried to do this, and in the 80s, they actually wrote an act that got introduced by, it might have been, it was one of the Republican senators. The rest of the Minnesota Chippewa tribe was ticked off at Mille Lacs because they were trying to do that. And the problem from the Bureau of Indian Affairs standpoint was that the argument that I was making earlier, that the other bands felt that if there were Minnesota Chippewa tribe lands held inside the Mille Lacs reservation boundaries, that they all had a right to those lands. And so, I mean, the tribe seceding had an impact on the other 5 bands, and so they all objected to it. So Oberstar was the congressman at the time, and he was very powerful, and he did not allow Mille Lacs to secede. But now there's movements by other bands to attempt to do that, and that either has to be done by an agreement of the Minnesota Chippewa tribe, or IRA constitutions can be revoked by an act of Congress. And so that's another route you could go, but you probably need the agreement of all 6 bands. So it's really legally tough to do that. But great question, because there are now, I think, a few bands that wouldn't mind breaking away from the Minnesota Chippewa tribe, but there's this constitution that's been around for a long time, and it's made it very tough to secede from without the compliance of the other bands. All right, so we get to this now. Was that the only question from that? I know we got a PL 280 question coming up. So.
Yeah, we'll pick up the other questions as we go here, but we can move into termination now.
Sure. Well, so Congress takes another swing here to the right, so to speak. And this kind of came about through a confluence of different things. One was, and Joseph and I were just talking about this today, the guy who ran the Japanese internment camps was named Dylan S. Meyer, probably one of the more checkered careers in American public policy, but he first ran the Japanese internment camps, and then he became the head of the Bureau of Indian Affairs. And the other character that plays a role here is Herbert Hoover, the former president from 1928 when the Depression came around. And Harry Truman called him up and said, "Hey, how would you, improve the federal government?" So one of his ideas was, termination of Indian tribes. And then there was a senator from Utah named Watkins who also wanted to terminate Indian tribes. And so, so for whatever reason in 1953, and I don't know, Congress might have seen this as a reward for another reward for soldiers fighting. And they always think if they assimilate Indians into the mainstream of the population, they're doing tribal Indian people a big favor. But anyway, so in 1953, Congress passes House Concurrent Resolution 108, which passed both the House and the Senate, and essentially picked out certain tribes and said, we want to, the rug of the trust responsibility that flows to these tribes, we want to yank it. And like a century before, or 120 years before when they passed the Indian Removal Act, it was kind of this general statement of policy. And then there were acts that terminated one or several Indian tribes. Altogether, I mean, today in the US, there's, I think, 574 federally recognized tribes. But during the termination era, 109 tribes got the trust responsibility yanked. So it was kind of like the Indian Health Service, the BIA, all those services, those promises got made in treaties and later in statutes, got yanked from 109 tribes. About 60 of them were in California. The closest one to us here was probably the Menominee in Wisconsin, and Ada Deer, who later became the head of the BIA, lobbied the bill through to restore the Menominee Reservation. And that happened in 1973, and it was kind of the end of termination. But it was a really bad idea. And I don't know, Congress gets goofy ideas when it comes to Indians once in a while. And this is one of those times. It was just kind of an awful policy that took root in, about a fifth of Indian country. So, and then Public Law 280, which was the public law. What that means is every Congress has a number. And so one just started right now, and a Congress lasts for 2 years. So this was Public Law 83-280, which means it was the 83rd Congress of the 280th bill that President Eisenhower signed. So what it did was it took 5 states, Minnesota, Wisconsin, Nebraska, Oregon, and California. And those were states with, except for Red Lake in Minnesota, large checkerboarded reservations. There are a lot of non-Indians living inside the boundaries of Indian reservations. And so what that said was our worst enemy is frequently the county attorney and the state attorney general. And so the criminal scheme on reservations prior to Public Law 280 was misdemeanors went to tribal court and major crimes would go to federal court. What Public Law 280 said was okay, your worst nightmare, the county attorney and the state attorney general now are going to have criminal jurisdiction over your reservations in these 5 states. In Minnesota, Red Lake was exempted. Red Lake's one big solid chunk of Indian land that never fell into non-Indian, a lot of which never fell into non-Indian hands. So they were exempted. And so Public Law 280 means that the criminal laws of Minnesota suddenly apply on reservations in Minnesota. So it was all the reservations in Minnesota for a while. One tribe retroceded, my tribe, Bois Forte, and I'll explain that in a minute. But Public Law 280 was, again, it was one of those times where Congress stepped in. And it's one of the few times really where they said, okay, we're going to yank. I mean, this was just an awful era. So yanking the trust responsibility from 109 tribes and also imposing state jurisdiction onto reservations. These were both horrible acts of Congress and a big blow to tribal sovereignty, obviously, with the terminated tribes and also with the tribes that were suddenly put under state criminal jurisdiction under Public Law 280. It was a civil part of Public Law 280, and I'll get to that in a minute, but why don't we move on?
Sure. So we have another question about jurisdiction. For the question about Public Law 280, you've largely answered it. There is part of it about if a case went to the Supreme Court related to it, and indeed you're going to get to that in a little bit. But for the moment, Liz had a question. I think she might have had to step out to go to a meeting, but it's a good question that we should consider at least briefly. Who has jurisdiction? And there's all kinds of ways to think about jurisdictional questions on reservations, especially. In this case, she's wondering, reservation land owned by an individual tribal member, not in trust, right? So held in fee rather than trust status. Who has jurisdiction over that land?
Well, if it's inside the reservation boundaries, the tribe has jurisdiction.
And what about for criminal purposes? If we're on Fond du Lac, for example.
The state has jurisdiction over. So the state has criminal jurisdiction over all the reservations in Minnesota except for Red Lake and Bois Forte. And then there's a twist that comes later. But anyway, so is this an Indian or a non-Indian person?
It's an Indian person,
way,
right? A tribal member who individually owns fee land on a reservation. And of course, we can't really answer the question unless we know what the circumstance is and whether we're talking about civil jurisdiction, criminal jurisdiction, personal jurisdiction, so on and so forth. But I think you've gotten to it, Tad, where you note that the tribe is going to largely wield civil jurisdiction. And in the case of where Public Law 280 applies, like at Fond du Lac, where this question arises from, the state would wield criminal jurisdiction. Right.
Although, well, yes, that's right. So there's a few other twists.
Tad is gesturing toward a few twists that will come up as we continue along toward the present here. So Tad, back to termination.
Yes. Okay. So in 1956, Congress passed the Indian Relocation Act. And so at one point, Karen Diver, two of the tribal leaders in Minnesota grew up in other cities far away because their dads, like Karen Diver's dad, got relocated to Cleveland. Melanie Benjamin's family got relocated to St. Louis. And people were relocated all over the place. Minneapolis was one of the target cities. So there's a large Native American population in Minneapolis. But during this time, half of Indian people got removed, encouraged to relocate to cities. And my friend Doug Sam, who passed away a while back, said he was a young man during this time and he got offered a construction job in San Francisco and he took it and he moved out there. And yeah, he did have a job for a couple of months and then suddenly he was stuck in San Francisco for the next 10 or 15 years or something like that. Later on, he returned to Mille Lacs and became the Secretary Treasurer for many years. But the Relocation Act was another, kind of bad idea that an attempt to assimilate Indians, which, the termination and Public Law 280 was as well. So these are assimilationist policies that never seem to work out. So 1968, the Indian Civil Rights Act passes, and the tribes weren't really for this, but the Senate discovered a 1896 case called Talton versus Mays, and the holding in that case was, the question in the case was, does the Bill of Rights apply on Indian reservations? And the U.S. Supreme Court said, no, it doesn't. The Bill of Rights doesn't apply on Indian reservations. And so they started holding hearings in about 1962. The Senate did, and ultimately they passed the Indian Civil Rights Act, which is kind of, has a lot of parallels to the Bill of Rights, but there are certain things like there's no establishment clause, so there's no wall of separation between church and state in the Indian Civil Rights Act. And that was because a lot of the pueblos, for example, are theocracies where the elected leaders are also the religious leaders. And so if like a Chippewa reservation wants to declare the Medewin their religion on their reservation, they actually have the right to do that. There's also a right to counsel, but it's a right to counsel at your own expense, because in 1968, none of the tribes had the ability to pay for even a legal aid attorney. So anyway, the Indian Civil Rights Act resembled the Bill of Rights in a lot of ways, although there's no Second Amendment. There's no right to bear arms. So for about 10 years, from 68 to 78, folks on reservations started taking their grievances against the tribal government up to federal court. Federal courts are courts of limited jurisdiction. They didn't want to hear these Indian Civil Rights Act cases. So in a 1978 case called Santa Clara Pueblo versus Martinez, the Supreme Court said the only time we're going to hear these Indian Civil Rights Act cases is if somebody's in jail. So if somebody writes a note to the local federal magistrate and says, I've been wrongfully imprisoned, that's called a writ of habeas corpus, I'm being held against my will. That's the only time the federal courts now will review the Indian Civil Rights Act. So it's really up to Indian tribes and tribal courts to interpret the Indian Civil Rights Act. So yeah, it's different from the Bill of Rights. And also under the Indian Civil Rights Act, it said that it was kind of the beginning of the modern era, because it said we're not going to extend jurisdiction, criminal jurisdiction, into Indian country unless tribes consent. And it also said, it had a provision in it that if a tribe that was under Public Law 280 wanted to retrocede in other ways, in other words, take their right back to have a misdemeanor court and have the feds prosecute in federal district court for major crimes, they could do that. So Bois Forte did that in 1973, largely because St. Louis County and Coochin County didn't want to go on to the Bois Forte Reservation because it's way up in northern St. Louis County, and they had a hard time enforcing the rights. They actually wanted the BIA law enforcement back, both the county and the band, and so they did a retrocession, which went through the state legislature, and then they offered the jurisdiction back to the Secretary of Interior, and he accepted it. So today, to this day, there's Bureau of Indian Affairs Police at Bois Forte, and there's a tribal prosecutor, there's a public defender up there, and there's a law trained judge up there. It's for years it was Margaret Peggy Troyer, and now it's her daughter, Megan Troyer. So anyway, and of course, Red Lake has had a tribal court and federal district court the whole time. So ironically, Richard Nixon, who was not the greatest president, was fairly positive when it came to Native American issues. And in spite of the fact he was vice president when termination was going on and started, he did a message to Congress, and Nixon looked very favorably on Indian tribes because when he was at Whittier College, he had an American Indian football coach. So he did this message to Congress saying we should end this termination thing and move into an era of self-determination. And so a lot of important stuff happens during the 70s. There's a lot of activism out in Indian country. The American Indian movement starts in Minneapolis, and it may have sparked some movements in Congress. Important case in 1974 that's important for both tribes and the Bureau of Indian Affairs and IHS. Morton versus Mancarey. Morton was the Secretary of Interior. Mancarey was a person wanting to get a job, but under the 1934 Indian Reorganization Act, the Bureau of Indian Affairs and the Indian Health Service had Indian preference in hiring. And after all the laws, the civil rights laws of the 1960s, this went up to the Supreme Court. And what the Supreme Court said is being an Indian is not a racial classification. Being an Indian is a political classification. And so the Bureau of Indian Affairs can do this. They can have Indian preference hiring, and so can tribes. So so the Supreme Court stood with tribes on the Indian preference hiring in those two agencies. And then Nixon was impeached and resigned in disgrace, but I'm guessing Gerald Ford signed the Indian Self-Determination Act. And so up until this time, the Bureau, it was their responsibility and IHS to carry out the trust responsibility that flowed from the treaties and the statutes to the tribes. But the Indian Self-Determination and Education Assistance Act allowed tribes to break off certain parts of the trust responsibility and have tribal members carry out those duties. So if, for example, if Red Lake had 7 BIA foresters, the tribe could take over 2 of those positions, and the feds would have to do a contract, which was called either a self-determination contract or a 638 contract. It was Public Law 93 638. And so tribes started doing that quite a bit. And this was a capacity building act. So tribes were gradually taking over more and more Bureau duties under this act. A lot of important acts passed during the 70s. When I got a chance to interview Walter Mondale, he thought when he was vice president, the Tribally Controlled Community College Act passed, which brought more colleges and places of education and higher learning to reservations. And he thought that was one of the more important things they did. Also, the Indian Child Welfare Act, because a lot of Indian kids were getting adopted off of reservations without the tribes being involved in their placement. And so the Indian Child Welfare Act, as a tribal attorney, gave me the right to go intervene on state cases and have a say with our tribal social services as to where the child was placed. And then by the late 80s, the Self-Determination Act kind of was still the BIA controlling reservations. And so people like Roger Jourdain and Art Gabo and Wendell Chino, who was the great grandson of Geronimo, and Joe Dela Cruz from the Pacific Northwest, a lot of legendary tribal leaders who have walked on, got together and said, rather than having 14 self-determination contracts, we want the money in one big chunk, and we want to be able to prioritize the spending ourselves and be able to create programs on our own. So if there's a person going through treatment and they rather go through a sweat lodge rather than going through a regular treatment facility, they could do that under the self-governance. So in '88, there was a demonstration project originally with 20 tribes. Then in '94, it so happened I was the staff director and counsel for the subcommittee on Native American Affairs for the House. We got permanent self-governance through and they were going to take in 20 tribes a year. And and then in 2000, Indian Health Service, there was actually a better act written for Indian Health Service for self-governance. So what you would do is enter into a compact with the United States, and each year you do an annual funding agreement under the Self-Governance Act. Today, about half of tribes are under the Self-Governance Act, more so in Indian Health Service, and partially for that reason, because tribes found that the delivery of health services was better done by their local doctors. And this is especially true in Alaska. Most of the native villages are under self-governance, and I think most of the Chippewas in northern Minnesota are self-governance tribes as well, under both BIA and IHS. So few things in addition. Do we start with ceremonial stuff? So 1978, another important thing happened. After all this, and there were provisions in the Code of Federal Regulations that precluded certain types of dances and certain religions on reservations. And after Wounded Knee in 1890, when the Army broke out, when people were practicing something called the ghost dance, and the U.S. Army thought they were rioting or something, so they killed a whole bunch of folks in December of 1890. A lot of American Indian religions went underground because we have the moccasin telegraph. So it was like, hey, take your religions underground, everybody, because the feds are killing people. So 78. And one thing to mention here, a lot of this stuff was done by a couple of staffers Mo Udall hired a guy named Frank Ducheneau, and Scoop Jackson, who was a powerful senator from Washington State, hired a guy named Forrest Girard, and they ended up influencing them. And they were, Frank's still alive, he's 81. He's from Cheyenne River Sioux, Lakota person. Forrest was from one of the Washington tribes, I want to say Colville. But they got a lot of this stuff done, and they're kind of, nobody knows their names, but this was like the inside people that were, a lot of people know the American Indian movement folks, but these were the guys working inside the House and the Senate to change things. So they managed to get the American Indian Religious Freedom Act through, which doesn't have much teeth really, but kind of said, rather than taking away people's religious freedom on boarding schools and other places over the years, Indians have the right to practice their religions, period. And I actually became Frank Ducheneau's deputy in 1990, and they were right in the middle of writing the Native American Graves Protection and Repatriation Act. And this just came up when I was working at the University of Minnesota. And I got this job. I'm senior director of American Indian Tribal Nation Relations. And I got there and I found out the U of M had been violating NAGPRA since its inception. So this was 2020 when I got there. And the U of M went down and dug up about 186 people along the Mimbres River in New Mexico from 1928 until 1932. And in 1989, they ended up having to, under the new state law, had to give the bodies over to the Minnesota Indian Affairs Council, but they kept the funerary objects. And these Mimbres pots that got buried with people are very valuable, and they're worth, they can't, under this federal law, they're supposed to return all this stuff, which you're now in the process of doing, because several of us raised a big stink about it. So anyway, but the head of the Wiseman Art Museum felt that she had the right to hang on to this stuff. And then I got there and there was this one anthropologist who came to me and said, we've got all this stuff. And I was like, oh my God, do they know they're violating a federal law? And so, what they could have done to the University of Minnesota was held back all their federal funding for 30 years. But they never, the US attorneys almost never prosecute on this stuff. But this stuff is worth like $150 million. This would be on the black market, but you can't sell it any place because it's illegal. What they're supposed to do is, and what they're doing now, is returning the stuff to the Pueblos. The Pueblos want the bodies and the funerary objects back. But when they started this act, they were starting to build the National Museum of the American Indian. And they discovered there were 34,000 American Indians in the basement of the Smithsonian. So they discovered all these museums had human remains. The Army, the cavalry, used to go out and dig up Indian people and bring them back to the East Coast, where they'd be put in museums for whatever reason. So, as horrifying as that is, and the new president of the University of Minnesota, who I work for, was horrified when she discovered this, and I explained that we're breaking the federal law, and she's a lawyer, and she was like, let's get on this. And so there was fairly rapid movement after that. But anyway, they were they were breaking the law, and the MIAC passed a resolution requiring them to return all this stuff. So anyway, NAGPRA is a huge deal on reservations because you can't desecrate Indian lands where there are graves, and you can't do it on national parks or other federal lands either. And so, and if museums have any of this stuff and they get any federal funding, they can get all their federal funding withheld. So as morbid as all that is, it's, you know, and as crazy as it is to go around collecting bodies, I mean, there were, Indians had enough influence, and Mo Udall was still, that was his last year in the House, but he got this bill through as one of his final acts. So why don't we move on, Joseph? Okay, so this is kind of interesting. I was mentioning Peggy Troyer earlier, and there, she'll come up in this story, and then there's a guy who used to be a professor at the University of Minnesota Law School who became the head of the BIA. His name is Kevin Washburn. And he went up and did research on a case called Bryan versus Itasca, and ended up writing a law review article called How a $149 Tax Case Became a $200 million Industry. And I think it's really now, it's like a $32 billion a year industry. So this is one of the foundational cases for Indian gaming, Bryan versus Itasca. Helen Bryan and her husband had a trailer in Itasca County on the Leech Lake Reservation. And what Itasca County and the state of Minnesota thought was, so there was a criminal part of Public Law 280 that everybody agreed applied, and the Attorney General and the county attorney got to prosecute Indians on the reservation. But there was a civil part of Public Law 280, and that was kind of like the argument that Itasca was making. Itasca County said, well, we can tax this trailer because we have civil regulatory jurisdiction over the reservation. So, and the Indians on the reservation. And so Helen Bryan ended up hiring a lawyer who was a legal aid attorney named Bernie Becker, who, you know, kind of did this stuff for free. He went to the U.S. Supreme Court, and Peggy Troyer was watching the case because she was a student, I think, at American University Law School. And anyway, so Bernie Becker loses this case in the Minnesota State Supreme Court and goes up to because the state of Minnesota thinks they have the right to regulate things on reservations because of Public Law 280. So he takes the argument to the U.S. Supreme Court and makes the argument that the tribes retain the right to regulate on the reservation, and takes it up to the Supreme Court in Bryan versus Itasca in about 1977. Supreme Court agrees with the tribe and Helen Bryan and says, no, that's not what Public Law 280 means. Yes, the state has criminal jurisdiction, but no, it doesn't regulate civil regulatory things on reservations. So you started seeing more and more tribal license plates around in the late 70s, early 80s. And then tribes started saying, okay, bingo is legal in the state of Minnesota and other states too. Bingo is legal in almost every state except for Utah and Hawaii. And so bingo is usually regulated by the state. So if the Knights of Columbus or the Catholic Church or the Moose Club or the Elks Club, or there used to be a lot of these men's clubs around, they would have, sometimes churches would have casino nights too, but they mainly play bingo. But they'd regulate at the state level, and so the state pot limit might be like $500. So they could have a charitable night where they play bingo. And I used to do that at Catholic Church when I was growing up all the time. But the tribes looked at that and said, okay, we can do this. It's not illegal in Minnesota, but those pot limits that the state legislature passed, those don't really apply on reservations. And so we could have bingo pots of more than $500, 600 or 6,000. And so 10,000. So that then after Bryan versus Itasca and a couple other cases, the great age of bingo starts in Minnesota. So this is when Little Six starts at Shakopee, and Fond du Loup starts up, and everybody starts having a bingo palace. And then for about, again, about 10 years, this gray area of the law, finally the little tribe of Cabazon out in the desert of California, takes Cabazon to court. They say, you can't do this stuff. Goes up to the Supreme Court, and the Supreme Court said, we don't see any, if it's regulated by the tribe and it's not illegal in the state, we don't see any reason they can't do it. And it's, again, inherent tribal sovereignty. Suddenly, the feds step in and they pass the Indian Gaming Regulatory Act. And what's good about the Indian Gaming Regulatory Act is that there was something called the Johnson Act, no relation. The Johnson Act said you can't gamble on federal lands. And so the Indian Gaming Regulatory Act, probably one of the more important things it did was waive the Johnson Act. And so it opened up things to go beyond bingo. And so it also created this jurisdictional scheme, Class 1. If you've been to a Chippewa powwow, there's people playing the moccasin game. That's Class 1 gaming. It's regulated by tribes. Class 2 gaming is bingo and pull tabs, and that's regulated by the National Indian Gaming Commission. Class 3 gaming is negotiated in a compact between the state and the tribes. And so Minnesota was one of the first states to negotiate compacts. And when a legal dispute arose, they took it to the federal magistrate. So I don't know if you remember, Bernie Becker, the guy who argued Bryan versus Itasca, was a federal magistrate that decided the scope of gaming in Minnesota. And essentially what the tribes argued was that video slots could be legal in Minnesota and blackjack. And so every tribe in Minnesota has those two compacts. And Bernie Becker died like two weeks after he made that decision. So the state never appealed it. And they settled with the tribes for those things. And there could be technological upgrades on the video slots. And so you'll see a lot of technology change. But Donald Trump was testifying in front of our subcommittee in 1993. And he said, this Indian gaming is going to be the biggest scandal since Al Capone. And anyway, but as it turns out, what was going on was the Mashantucket Pequots were in competition with his Atlantic City properties, which eventually went bankrupt. Foxwoods is still there, so is the other tribe in Connecticut and tribes in Massachusetts and other places that, so Trump goes out of business. But I would argue that Indian gaming is one of the most heavily regulated industries. So once the state and the tribes agree on a compact, it's regulated by the Secretary of Interior has to sign on to it. And then I'm trying to get Feathers Post out of the way there. The Department of Justice plays a role. The FBI looks into background checks. The Treasury Department is always watching cash transactions at certain levels. The National Indian Gaming Commission regulates gaming and also management contracts that tribes may have with like Harrah's or something like that. In Minnesota, the state government, the State Department of Public Safety plays a significant role in regulating gaming. And last but not least, the tribes play the largest role in regulating Indian gaming because they don't want a dime leaving the reservation that should be going into their pockets. And so once you walk into a casino, there are things called minimum internal control standards. So there's either a human eye or a camera following you anytime you're in a tribal casino. So anyway, so tribes regulate the heck out of their casinos, and so do the feds and the state. So anyway, and Donald just lost out on that one. So all right. So being good stewards of the earth, Congress recognized that as early as the 80s, and the Environmental Protection Agency, which was actually a Richard Nixon idea, got created in his administration, and then they did a policy statement that was favorable to tribes taking jurisdiction on reservations over environmental policies. And so from 86 until 1990, there were a series of amendments to the Clean Air Act, the Safe Drinking Water Act, and the Clean Air Act, Safe Drinking Water Act, and the Clean Water Act that allowed tribes to be treated as states for environmental purposes. And so suddenly the tribes and the EPA could take over jurisdiction. So tribes could do stuff like declare themselves sole aquifer, provide, imbue themselves with sole aquifer designation on reservations. So anyway, this was an important advancement and of tribes taking over, using their sovereignty to take over the right to regulate the air and water within their reservation boundaries. And then, there's some people that feel that even on ceded territories, we have some rights because, but that's something that's probably going to be litigated at some point. There's this new rising area of environmental law called essentially environmental justice, where if like in Flint, Michigan, if you're hurting a particular group of people, and that if you're particularly hitting some disparate group, like in rural Minnesota, frequently it's Indian tribes that are using polluted water. So in the 1854 territory, there's a lot of mining that goes on. And I think the question is, we clearly have the treaty right to hunt, fish, and gather in that territory, but do we have the right to do that in clean water? And I think that's something that may come up in the years to come. So next one. So law enforcement has been of particular interest. In Minnesota, in 1991, Mille Lacs was the first tribe in a public law 280 in Minnesota, at least in a public law 280 jurisdiction, because folks started coming onto the reservation with gaming and they needed more police. And what they wanted to have is post-certified police officers that are certified just like state cops. And so they passed a law in 91, the state legislature did, allowing for Mille Lacs to enter into agreement with Mille Lacs County to have a law enforcement agreement. And cases would get prosecuted in state court, but there could be police officers that worked the reservation. And then in 1998, the state amended the law so that any tribe could enter into a law enforcement agreement with any county. And so Mille Lacs ended up entering into an agreement with Pine County. And so if they had reservation land in other counties, they could enter into any tribe can enter into an agreement with another county. Usually it's because you have trust land there. So anyway, but on the federal side, in 2010, the Tribal Law and Order Act passed. And what the Tribal Law and Order Act said was there could be a return of federal jurisdiction. So the Major Crimes Act, if crime got bad enough on reservations, the U.S. attorney could step in and prosecute. If the tribe petitioned the U.S. Department of Justice to say, hey, we're like in Minnesota, crime was fairly rampant on White Earth. And so White Earth was the first tribe in the nation to petition the Department of Justice under the Tribal Law and Order Act to get some federal help on criminal jurisdiction. So if the U.S. attorney wants to, and the major crime occurs on White Earth, the U.S. attorney can prosecute it. And they do once in a while, but they have their discretion. Mille Lacs got under the Tribal Law and Order Act in 2017. And so far, those are the two tribes that are under that act in Minnesota. And so that's important. I think in the years ahead, you'll probably see more tribes getting under that. In 2013, actually, Joe Biden was the original author of this act, the Violence Against Women Act. And the amendments in 2013, there was a law professor in Minnesota named Sarah Deer, and she was significantly responsible for these, and other actually Minnesota lawyers and women's groups were responsible for getting this provision in, because what was happening on reservation frequently was there would be non-Indian men beating Indian women. And when they would fall through the jurisdictional cracks, and the states would not prosecute them. The tribes couldn't prosecute them because in 1978, the Supreme Court, there was a case called Oliphant versus Suquamish Indian tribe that said that Indian tribes cannot prosecute non-Indians under any circumstances. And so we lost criminal jurisdiction, another blow to our sovereign status in 1978 in Oliphant case. And we've been trying to overturn that case ever since, but it's almost impossible to do. But this was the only place where Oliphant got slightly overturned. And it's just in the narrow case where there's a non-Indian man, or it could be vice versa. It could be a non-Indian woman beating an Indian man, I suppose. But I mean, it's the Violence Against Women Act. So 99% of the cases are women being beaten by American Indian women being beaten by, non-Indian men inside the reservation boundaries. And so in that narrow circumstance, tribal courts can take jurisdiction over these spouse beaters or whatever you want to call it. And so this was a really controversial provision in this act. And, it was done during the Obama administration. And I think it's going to need reauthorization in the future. And now that the Democrats are controlling the House and the Senate again, we have a chance of getting that back into the, getting it reauthorized with that provision in it. But that's our one narrow exception to the Oliphant case. And it was because women were getting beaten and the men were getting away with it. So.
All right, thanks, Ted. So that brings us to the present on the Tad Johnson time machine, as I like to call it, the river of time. We've got a few questions. Should we dive into those?
Sure.
Okay, so well, first, an extra bit of information to the gaming story. We've got a contribution here explaining that Peggy Troyer advised Bernie Becker regarding PL 280, explaining that tribes didn't ask for or want PL 280, and then Becker changed his argument, which contributed to winning the case. So more of the backstory there. Thank you for that.
Actually, Peggy Troyer told me that story, and yeah, he was kind of screwing up the case. So had Peggy straight. So rest in peace to both of them.
So a couple of kind of big picture questions. One asks, is there a way that tribes could go to the US government collectively, like collaboratively as a whole, and ask about education and health benefits? Is this something that tribes could approach this together as a collaboration to try to pursue change?
Yeah, I mean, there are organizations the National Congress of American Indians is the oldest and largest Indian lobbying entity. And they now have, thanks to Shakopee, have a place on Embassy Row. Indians have achieved new clout with the Congress. And there are, for example, the two ways to influence Congress is votes and money. And so tribes, some of the tribes that can contribute large amounts to help out all Indians. And there's a couple of places where Indian Health Service, for example, has only ever been funded at about half the need of Indian country. And a lot of casino money goes into healthcare and housing and things like that. And under the law, it's supposed to go into that sort of thing. But it's because the feds aren't holding up their end of the trust responsibility. And yeah, there's lobbying efforts constantly going on to try to upgrade the trust responsibility. But the interesting thing that's happened over the last few years, when Obama was president, for example, and hopefully we're getting back to this, his first question for the tribes was he invited all the tribes out to the White House in 2009 and wanted to know how we could best consult with them. And so no matter how remote the agency was from Indians, they were required to do a consultation policy. Then in 2013, Dayton did a consultation policy for the state agencies. and Walls and Flanagan did a much better one in 2019. So anyway, the state is coming around on some of these services. But yeah, as far as lobbying, I mean, I think there is a concerted lobbying effort to try to, hold the feet to the fire of the federal government. But there's a number of caucuses in the United States House of Representatives, and like the most famous one is the Black Caucus, and they fight frequently for civil rights. And there's agricultural caucuses and stuff. The largest caucus in the U.S. House is actually the Native American caucus. Not that there's that many Indians in the House of Representatives. It's just that people who have like Betty McCollum from Minnesota, who's controlling all the Indian money now in her subcommittee, but she's from St. Paul and has always had a great friendship with the tribes of Minnesota. She and a congressman from Oklahoma were chairing the Native American caucus until Deb Haaland and the congresswoman Kansas came in, and so now they're chairing the Native American caucus. But that's actually all the people who have Indian tribes in their states join the Native American caucus, and so you got folks from Arizona, New Mexico, et cetera. And so that's a proactive group, and they actually have staff that work with them just on Native American issues. And that's when I was working for the House, we didn't have that, but that was and that was a result of tribes swinging a couple of elections in places like South Dakota. Tim Johnson got elected both the House and the Senate with the help of the tribes. He was a Democrat in South Dakota, and it's really hard to be a Democrat in South Dakota. Similarly, John Tester from Montana got elected to the U.S. Senate with the help of the tribes, and so I think he could be the chair of the Indian Affairs Committee if he. But anyway, so in smaller states, tribes can play a big role in voting in people who are sympathetic to tribal causes. Actually, and McCain was actually fairly good, rest in peace, on Native American issues. And when I was working for the House, frequently I would consult with his people because they would know what Republicans were going to object. So I worked very closely with McCain's staff to kind of figure out if we can get a law through the House and the Senate. And obviously we worked with Senator Inouye's staff, who were excellent. Both of them were very good, but frequently we could get more information on what the Republicans were thinking from McCain's staff. So anyway, I mean, right now I think there's this era where tribes have a certain amount of clout in the House and the Senate, because in the 70s, they made the Senate Indian Affairs Committee permanent, and it had been a select committee on Indian affairs. And then the Senator Inouye used to say it was a committee that you kind of nobody wanted to be on, and then it became a committee of choice. Now on the House side, there's a subcommittee on Indian affairs and Alaska Natives, and the chairman of the Natural Resources Committee is Representative Grijalva, who has a lot of tribes in his district. So he's got Mo Udall's old district. So it's not a bad time for Indians right now in the House. The problem is when I was there, we used to do a lot of bread and butter issues, healthcare, housing, those sorts of things. And now with the advent of gaming, things become sometimes it's tribe going against tribe on who gets land in trust to build a casino. And anyway, but the short answer that was a long way around to say, yes, tribes could do uniformly try to lobby Congress on a regular basis, mainly for appropriations for HUD housing, IHS, BIA budgets, and they act as frequently as one voice. And that's where the National Indian Gaming Association comes in on economic development issues. And that is also a huge presence in Washington. And NCAI, there's also the National Indian Housing Board, there's an education association, of course, which kind of started in Minnesota. So anyway, and Devery probably talk about that.
Yeah, part of that you were addressing there was Devery's question about the importance of tribal lobbyists. We have a question submitted on behalf of Sally Fine. If tribes treated with other tribes, do you think this would build sovereignty?
Yeah, there's no reason they can't. And actually, I think there's more tribes thinking of things like that, and especially with regard to trade and commerce. It's kind of like it'd be nice if the tribes were, and they do this a lot. I mean, they don't necessarily enter into treaties, but they could. They're sovereign to sovereign. So I mean, for commerce purposes, my friend Richard Monette, who's a professor at the University of Wisconsin, points out quite a bit that, commerce has been going on here for, tens of thousands of years. They found copper from Michigan in Mexico. So there were all kinds of trading going on. And I mean, we should be getting back into that. I think as tribes get more sophisticated in economic development, they'll probably recognize the utility and better ways to enter into agreements with each other. But the treaty is a fine way to enter into an agreement with somebody else.
Yeah, and we might think of things like GLFWC, the Great Lakes Indian Fish and Wildlife Commission, or the 1854 Authority, as diplomatic arrangements between sovereign tribal governments to create collaborative governing institutions, natural resource conservation institutions, which is maybe along those lines. Okay, so the next question here, pretty technical. If there's a deep injection well placed within a reservation, does the tribe have authority to implement compliance or disabling measures to protect the aquifer? I'm glad my lawyer is here.
I was going to say, this is like a law school question. It's a really good one. Can I get back to you on that one? I think that's an awesome question. I mean, as a lawyer, I would make an argument that, hey, we have the inherent right to do this, but it might depend on where it is. But that's a heck of a question, and I'm embarrassed that I can't answer it. This is when Ed Fairbanks used to come in handy. So
I think I mean, it's on a reservation. I think, what is it, Mitchell comes to mind. If this is going to impact the sovereign integrity of the tribe, if this is going to impact the health and wellness of the tribe, then the tribe could make the case that it has the regulatory authority, and there's a test that the federal courts to use, and this sounds like it might pass that high bar, but we'd probably have to know more and do a little bit of studying on this one.
Yeah, I'm curious if that's an actual situation. It's a really good question. I mean, as a tribal attorney, I would always make the argument that yes, the tribe has jurisdiction over everything. So anyway, but it's a tough one.
So Tad, a question related to your current wheelhouse working for the University of Minnesota, this one about Michigan. Is the Michigan Indian tuition waiver related to trust responsibility, or is it a result of being a federal land grant university? In any case, will the University of Minnesota do the same?
Well, I think the University of Minnesota should. There's been a series of articles called land grab universities in what is it, High Country News or magazine anyway. But it's this guy is a graduate student at Harvard, and he did a lot of research on land grant institutions and found that a whole bunch of land grant institutions got built out of Dakota land from the Treaty of 1851 and also the 1837 treaty. A lot of land from that was used to build universities. And so what happened was, so the United States has a trust responsibility because they took all this land from Indians. Land tribes ceded all this land, and they said, you can exercise these rights, and we'll have a trust responsibility to you inside your boundaries to provide housing, health care, education, that sort of thing. But under the Morrill Act, which was an 1862 law, which provided for land grants, it was kind of a big literally a land grab for universities without any promises to tribes. And it seems to me like there should be somebody should say, oh yeah, we should have done something for Indians. And it's not too late, because they've, as somebody pointed out here, they did it in Michigan. And I would like to do research on exactly why they did it in Michigan, because I want to make that argument at the University of Minnesota, because I think we should be offering something like that. But like Morris, the difference between like Morris and the Michigan tuition waiver is, I think Michigan requires you to be a member of a federally recognized tribe, whereas Morris will allow you in if you're a descendant of a tribe. So anyway, I think that's something we got to push for as educators.
Great. And then a
'cause
question from Devery here about the Bolt decision. Do you see something like that happening again? And then Devery particularly emphasizes the Bolt decision to allocate 50% of the fishery to tribes, 50% to the settlers. Do you see something like this happening again? What's the current sort of considerations of natural resource controversy right now?
Well, that's a really good question, Devery. So the Bolt decision was kind of the one of the key decisions on hunting, fishing, especially fishing rights. Trump just appointed all these conservative judges, I mean, but we've seen. So this case, that the McGirt case that just came down from the Supreme Court, that kind of said half of Oklahoma is now Indian country, and kind of the city of Tulsa is right in the middle of that decision. And so I never thought they would win that. I mean, but in beautiful language, this conservative judge that Trump appointed said, at the end of the Trail of Tears, there was a promise, and they were supposed to have this jurisdiction. And so, a couple of weird things have happened in the court in the last few years. So then there's a case called Nebraska versus Parker that was a boundary case. And the court decided, this is after Scalia died, the court decided 8-0. And Clarence Thomas wrote the decision that the Omaha Reservation never ceased to exist. And then McGirt was essentially a case about, does the Major Crimes Act still apply? Because a Creek Indian killed a Creek Indian on the Old Creek Reservation. And what Oklahoma said was that, well, when we entered statehood in 1907 with our Statehood Act, all the Indian land came under our jurisdiction. Well, that went up to the Supreme Court last year, and they said, and Gorsuch said, no, this is still Indian country. So if an Indian kills an Indian there, it's a major crime, and it goes into federal district court. So that McGirt, the first case was not McGirt, it was a murder. McGirt, these are not nice people. So these are criminals. So McGirt was a sex offender, but the issue was who has jurisdiction over him in Indian country. And the Supreme Court said the tribes retain criminal jurisdiction. So misdemeanors go to tribal court and major crimes go into federal district court. And so the Oklahoma delegation's all apoplectic about that now. And they're probably going to try to roll it back. But so, I mean, it didn't answer Devery's question about whether that could happen today. But weird things are happening in court these days. And I think judges are getting, some of them are getting better training on federal Indian law when they're in law school. Like Harvard, the Oneida tribe of New York created a tribal chair at Harvard Law School because a lot of them go to the federal bench. And so and now I think other Ivy League law schools. I'm trying to get the University of Minnesota to hire a Native American law professor, not me, but I mean, like my cousin Bob was teaching at Harvard. He's got a cabin right next door to me here, and he wrote a case book on federal Indian law. Got tenure at Washington University of Washington, and then held the Oneida chair for several years, and now he's going to be the solicitor for the U.S. Department of Interior. So, but he's a graduate of the University of Minnesota Law School, but they don't have an Indian law scholar. They had a chair funded by a Devery probably recognizes his name, Marvin Sinosky, but they've never used that chair that was endowed by Marvin 38 years ago. And Marvin operated a huge, that's all he did was federal Indian law. He endowed a law chair at the University of Minnesota Law School because he went there, but they've never used the chair to teach federal Indian law. So I kind of nag people constantly on these things. So anyway, I'm trying to be the voice as well as I can of all the complaints we have against the university. So until I get fired, which would be a great honor. Anyway.
Great. Well, thank you all for your patience to travel with us down the river of time here. It's no short excursion, and we appreciate your endurance. Here on the screen, just to commit it to the video, we have some recommended resources. You probably know all about them, but we want to commit them to the video so that folks who come later can certainly consult Minnesota Makoche by Gwen Westerman, Bruce White, Anton Troyer's Ojibwe in Minnesota, Stephen Pivar's The Rights of Indian Tribes. And then there's also the Treaties Matter website and museum exhibit that travels around. They've got it at the Capitol too. The U.S. Dakota War website from the Minnesota Historical Society, and then the website of the Tribal State Relations Training that's hosted or led by MnDOT, though it serves all of the executive branch agencies for the state. A lot of useful resources on that website. And then also a recommendation from Devery, Kenneth Phillips' book, Indian Self-Rule. So we'll commend that to you as well. So thank you so much again for your questions and your engagement. Really grateful to be here and share this time with you.
Hey, Devery, can you email me sometime?
I want to say thank you guys. We appreciate it on behalf of the Minnesota Indian Education Association Board of Directors.